first and foremost, thank you for coming to seek advice. I will be advising you on your position regarding the current dispute that you have with the Human Resources at Create Limited concerning your employee status. The definition of an employee under Section 230, subsection 1 of the Employment Rights Act 1996 states that an employee is someone who works under a contract of employment, of which is classified as meaning a contract of service or apprenticeship under subsection 2. Unfortunately, this statutory definition is extremely vague and provides little assistance. However, allows us to make the distinction between an employee who works under a contract of services and the self-employed who work under a contract for services. So, to determine which status you fall within, we will apply several tests devised by the courts and consider the factors that are present in or absent from your case. Weight those pointing towards employment against those pointing towards self-employment, and then stand back and look at the entire picture as Judge Nolan suggests in the case of Hall and Lorimer. The first test I would like to apply is called the control test and focuses entirely upon the degree of control that Create, being the employer, has over the alleged employee, being you, Rhiannon. This test is supported by the case of Yams and Noakes. In order to be classified as an employee, you must be subject to a certain degree of control by Create, which may include how, what, where and when you perform your service. I note that you're required to spend at least 20 hours per week working at the company's premises, which evidently demonstrates an element of control that Create has over you, whereby firstly, they indicate the minimum hours that you're required to work, and secondly, where those specific hours need to be carried out. I'm also aware that you're required to be contactable in the event of any emergencies relating to the software, which further displays an element of control in that Create requests that not only would you be required to be contactable, but presumably act accordingly should such situation arise. The specification of a place to work, alongside the requirement to work a set amount of hours and be contactable, all indicate that you are treated as an employee. Whereas if you are treated as being self-employed, for example, you are only likely to be given a date of completion and be subject to no control other than this. On the other hand, it cannot be avoided that you have the liberty to decide which days and additional hours you work, alongside where you work outside the required 20 hours on the company's premises. This obviously demonstrates a certain degree of freedom and lack of control from Create. However, if it is an agreement that has been made with Create, such circumstances will not be seen as material to classify you as self-employed. Another factor that we should consider when applying the test of control is that your service is highly skilled. That's a lack of supervision or control concerning the mode of working, for example, are expected and therefore, again, not likely to be seen as material. I'd now like to consider the next factor, which asks whether you're required to provide your services personally. Consideration must therefore be given to whether or not you could provide a replacement worker in your absence. This is also referred to as the right of substitution and would only find you to be an employee if Create and yourself understand that you could not provide a suitably qualified or skilled person in your absence, as in the case of ready-mix concrete. Further, if it would be you that would personally have to pay that person, it would more so suggest that you're self-employed. Merely having the right to propose a substitute rather than the right to actually send a substitute, however, is only likely to be a mild pointer to self-employment. Now if we consider the minimum obligations that are necessary for a contract of service. So firstly, there is an obligation on you to provide that service, and there is similarly an obligation on Create to pay you for that service. Therefore, if you're able to turn down the work that Create may or may not offer you, then this test would render you self-employed. If this mutuality of obligation doesn't exist, then one cannot be classified as an employee, as there can be no contract of employment. Another indicator of employment status that should be considered is the provision of equipment that is used to perform your service. Generally, providing your own equipment to perform your service would suggest that you're self-employed, as supported by the case of Willie Scheidegger, Swiss Typewriting School and Ministry of Social Security. In contrast, you have informed me that Create provided you with your desk and laptop, which is the fundamental equipment required to do your job as a software designer. Therefore, such actions would suggest that Create have treated you as an employee. I'd now like to address whether you're subject to any financial risk, as individuals who risk their own money, for example by buying assets needed for the job, bearing the running costs or paying for overheads or materials, are almost certainly to be regarded as self-employed. Also, if the job overruns, which had previously been quoted a fixed price, or should you be required to rectify unsatisfactory work in your own time and for no additional payment, then they would also suggest that you are self-employed. I reiterate that any additional hours you do work are submitted by the invoice, therefore the possibility of you bearing any additional costs does seem very unlikely. To conclude the application of this test, employees are not expected to risk their own capital, and the information provided does not suggest that you do that in practice of your employment. Therefore, suffice to say, this test would suggest that you're an employee. Questions raised by the topic of finances may also include the method of payments that Create uses to pay you. Being paid by the hour, week or month would generally suggest that you're an employee, and alternatively quoting a fixed price for a job would indicate that you're self-employed. Rhiannon, you have informed me that you spend a minimum of 20 hours per week at the company's premises and again submit the invoice for the extra hours. Having not had the chance to explore this requirement with you further, it's somewhat ambiguous in that it could be interpreted to suggest two things. Firstly, that you're either paid an hourly rate resembling employment, or secondly, that you are self-employed as you are paid a fixed rate for an agreed time to work and then submit your invoice for the additional work performed, as opposed to submitting overtime, for example, as you would being an employee. You'll therefore need to consider and clarify Create's method of payment to you to determine what employment status it would point towards, and again consider the points that I've just made. One factor, however, does seem certain is the inability for you to make profits by reducing overheads, for example. This would therefore suggest that you're an employee, as someone who is self-employed would generally be able to achieve a profit or loss for that matter. We'll now consider a test applied in the case of Stevenson, Jordan and Harrison, and McDonald and Evans. This is the integration test, and it analyses your role at Create and asks whether your service is considered to be an integral part of the business, or whether you conduct business similar to someone performing services who is self-employed. The fact that you're required to be contactable in the event of an emergency on its own would suggest that the role is integral. Therefore, I'm happy to say that the application of this test would also point towards employment. The presence or absence of employee benefits may also be a fundamental indication of your employee status. You've already mentioned that Create pay you both holiday and sick pay, which, needless to say, are both classified as employee benefits and wouldn't be achieved by someone that Create will consider to be self-employed. In addition to these, there are several more benefits that could suggest your employment. So should any of the following be applicable to you, then your potential status as an employee would be supported. So these include stuff like membership to Create's pension scheme, access to the grievance procedure, being subject to the disciplinary procedure, and the right to terminate engagement by giving the requested notice. In contrast to the employee benefits that you receive, where you're classified as an employee, you are in contrast personally responsible for paying your own tax and national insurance, which would signify that you're self-employed. As if you are an employee, for example, Create will be responsible for paying this. However, it is important to consider that if you intentionally pay your own tax and national insurance for possible taxation benefits, then it could be argued that you could be classified still as an employee, as in the case of Davis and New England College of Arundel. Another element to consider is the length of a particular engagement, which is in fact neutral in determining employee status. Whilst it seems to have little importance in determining employee status in some cases, it's been credited in such cases as Hall and Lorimer. Therefore, it may be suggested that having worked at Create continually for 3.5 years, that it could support you being an employee. Secondly, it's essential to inform you that the question of employment status must be asked for each job. Therefore, if you've been classified as an employee by another company for the work that you do for them, it does not necessarily mean that you'll be classified as an employee by Create. However, working for several other businesses performing the same service may suggest self-employment. Suffice to say, despite there being a few tests pointing towards self-employment, looking at the picture as a whole would, in my supported opinion, indicate that you are likely to be classified as an employee. in which case, Rhiannon, you will be receiving the bonus. I hope that I've provided you some clarification and your dispute is successfully resolved.